Today, we have two for the price of one. We have two partners with the firm Seyfarth Shaw, who is a proud sponsor of the Sports Lawyers Association. So I'd like to welcome Allison Silveri, partner in labor and employment, and Michael Marino, also a partner in labor and employment in two different offices of the firm. Welcome.
Thanks, Bobby.
Thank
Well,
you, Bobby.
even though we got two of you, we're still going to go through the same sort of formal start of our program. And we'll start with you, Allison. Can you talk to us a little bit about your practice and the path you took to end up doing what you do?
Sure. Thanks for having me today, having both of us. So, I am a partner in our Boston office in our labor and employment group. I primarily practice in the wage and hour space. Representing employers on wage and hour issues that arise, whether in litigation or on the advice and counsel side. So I spend probably half my practice doing that, and then half my practice doing more general employment advice, counseling, retaliation, discrimination, harassment, handbooks, policies, that type of thing. So, got to the point of being here today and talking to you because I was a collegiate athlete myself. I rode for the University of Michigan, then became a lawyer, and it seems like all my worlds are colliding with what's going on in the college space right now with the question of whether college athletes might or might not be employees of the universities that they attend. So it seems like everything's been coming together the last few years.
Great. Michael?
Thank you, Bobby. I too am kind of the beneficiary of the intersection of practice I've been involved in for decades. I started at Cornell at the Labor Relations School. And so I've been studying really collective bargaining and the labor movement throughout my entire career. That then intersected with the opportunity to work with sports and entertainment. Two kind of really pathways that are very enjoyable, lots of litigation in between. But I think that this space and I've worked with, of course, a lot of NFL-related athletes, specialized in a lot of football stuff and things of that nature. And I think we're kind of at a unique crossroads here. Since I had a concussion my freshman year in college, I didn't get the opportunity to actually participate. Probably was a blessing in disguise in many ways. But in any event, certainly an avid follower of all of these developments. And I think it's a very unique and exciting time. So I think that the perspective that I would augment or supplement from the expertise and substantive knowledge of the employment law that Allison brings is to look a little bit about what are the possible solutions and where does this whole idea, we're management labor lawyers, of course, but what about this concept of collective bargaining? And is that one of the potential solutions, in quotes, if you will, down the road to kind of framework where this is all going?
Well, that's a great introduction and a great jumping off point. And I know that for years I've been going to speaking at law schools, which I'm sure both of you do. And law students always ask me, what courses should I take? What is important? And I always say, if they still offer labor law, you should take labor law. Now, all these years later, I have these people who are now long practicing lawyers reaching out to me saying, I should have listened to you about taking labor law. And I go, well, yeah, it's everywhere, but particularly now. So let's sort of take a 50,000 view of the House settlement, which isn't quite done yet, and we're not sure when it's going to be done or if it's going to be done. But assuming it gets settled, we have basically, it was a settlement after the Alston case when the NC2A was told that they don't have any antitrust protection. It opened up a world of NIL. You have this consolidated case that we all refer to by its name. And there's two elements of it. There's the retro payments, which are for the value over a 5-year term in the statute that's going to be distributed in some manner to those of the class that are staying in the class. And then you have prospective payments, which are payments that will be paid directly to the athletes from the institutions based upon the use of their NIL, or so they say. That's where we're at. But for those of you that attended the SLA conference, we had very interesting perspectives. We had Jeffrey Kessler, one of the two lead attorneys in the litigation, talking about what he thinks is the right way to go. We had Scott Beerby from the NCAA talking about how the NCAA perceives it. And then I did an interview with Jim Cavalli, who has a trade association for athletes, where he thinks it might go. But for those that were there, Jeffrey Kessler even said, when questioned, yeah, this is not a comprehensive settlement. This settles an issue, and it opens up a lot of stuff. So on that theory of opening a lot of stuff, we have a series of cases. I think Johnson, Dartmouth, SC are sort of the big cases that deal with the employment issue that I think a lot of people are just pretending doesn't exist. But I've been saying from the jump that this is the thing that upsets the apple cart.
Yeah. Yeah, I think that's right. I'll jump in on this. So, the conversations at the conference were really interesting, and one of the things that Jim Cavalli talked about was how he sees, if the direct revenue sharing is permitted in the House settlement, he sees these agreements that universities might enter into with athletes as the first piece of evidence that will be used in Johnson as the potential evidence of employment status. And it's interesting because Johnson is still an open litigation. It's still ongoing. And the question that's before the court in Johnson is whether whether college athletes, and they're looking to certify a class on behalf of all Division I athletes, are employees under the Fair Labor Standards Act. And I think, there's two, we'll talk about collective bargaining, we'll talk about Fair Labor Standards Act. Under the Fair Labor Standards Act, it's where they're employees entitled to minimum wage and overtime. So that issue, what has happened is the Third Circuit found for the first time, there's been lots of litigation, Third Circuit finds for the first time that these athletes can state a claim. They can survive the motion to dismiss, right? So the Third Circuit announces a test. Other circuits, the Seventh Circuit, the Ninth Circuit found student athletes could not assert a claim under the Fair Labor Standards Act. Third Circuit says they can. So Third Circuit announces a test for whether college athletes can assert a claim under the FLSA, sends it back down to the District of Pennsylvania. Case is still there. So case is now back at the Eastern District of Pennsylvania. Following the Third Circuit's opinion, the plaintiffs filed an amended complaint. The case is back in the motion to dismiss phase. But that case is still percolating. Regardless of what happens in House, that case is not going away. And so I think that then you get into then the direct revenue sharing and the possibility of direct revenue sharing and what the colleges and the universities are, if they enter these direct revenue sharing agreements for the first time, what do those agreements say? What do those agreements look like, right? The third party NIL deals don't have the concern of employment and the concern of employment status. So, the third party NIL deals, it's a license to use your name, image, and likeness. It's a sponsorship agreement. It's a, you show up at my event, it's a signing, it's a, being in our commercials, and we'll pay you for that. But there's no question of employment status percolating around those third parties. And I think that question is percolating out there. And now the universities are entering into contracts, right, with athletes that will be analyzed in some way in connection with this other open litigation. So it's something that we think about a lot when we're talking to universities about entering into or possibly entering into these direct revenue sharing agreements. And I think something that there's lots of ways to do it, lots of ways to think about it. Happy to sort of talk through what our thoughts are on those. But I do think people can't forget, and universities especially shouldn't forget, that Johnson is out there as they are thinking about what those contracts might look like that they enter into with athletes.
So let me ask you a quick question. So if I go and somebody says, hey, I'm going to give you all the equipment you need to do a job. I'm going to tell you when to be at the job. I'm going to tell you where to be. We're at the job. I'm going to control what you do at the job. It seems to pass the duck test to me that it's an employee. But where's the court? Where are the courts going with trying to create some fiction that's saying it's not an employee? Because I've been asking this question for years.
Well, so the Johnson test, right? So this is the Johnson test that says they may be employees under the FLSA if they perform services that are necessarily and primarily for the other party's benefit, under that party's control or right of control, and in return for express or implied compensation or in-kind benefits. And the way that the Johnson court frames that test, like the majority court is pretty careful about how they frame the test. The concurrence sheds a lot more light on it, and it really reads like an athlete by athlete consideration, right? The answer to that test may be different for walk-ons than it is for scholarship athletes, right? The fourth part, it's a conjunctive test. All 4 prongs have to be met. So how you get there, and what the control is, right? Like, what kind of control are universities exercising? And there's a spectrum, no question. And I have we can talk a lot about what universities can be doing and where the spectrum falls. I have lots of thoughts on this topic. But, if a university is dictating, to take a most extreme example, if they're dictating what you can eat and what time you need to eat at, and, whether, what time you go to bed at, that sounds an awful lot like control. Telling you when you have to show up for practice, maybe not as much control, right? Like, there's a very broad range and spectrum. And I think it's sport by sport, it's athlete by athlete, it's very different university by university. So that piece of it, right? But to answer your question, if a revenue sharing agreement starts to say things like, you're going to show up at X time, you're going to do X, Y, and Z in exchange for this money that we're going to give you, that might start to look like an employment agreement. So that might be hurtful or harmful to a university's defense if pushed on the employment side under the FLSA. So I do think that's something that, I think there's a couple ways that revenue sharing agreements, I know there are a couple ways that they look and that they can be thought about, and as if assuming House is approved. But some, they can be a couple of different things. One way is it's purely a license, right? Purely a license for use of your name, image, and likeness, and the athlete doesn't have to do anything. There's no control. There's no requirement that the athlete does anything. And if the university never uses their name, image, or likeness because they don't want to, then they don't, but they've paid them a certain amount and they're going to pay it in whatever increment they decide to pay it in. And it's renewable at the end of the year, and they decide whether they're going to do it again the following year. But there's nothing the athlete has to do more than just grant the non-exclusive license for their name, image, and likeness. Another option, maybe, what if it's really revenue sharing? It's called revenue sharing. So what if it's, hey, athletes, we'll pay you X percent of whatever the revenue is from the volleyball game. And then athletes can go and generate, go on social media, get people to come and buy tickets to the volleyball game. And then they can get a percentage of whatever the revenue is from that game. There's different ways to structure these agreements that are in fact revenue sharing agreements, and that could solve the question for universities that don't have a lot of funding, but still let them be in on this game. There's so many different ways to do this, but the biggest thing is they shouldn't be employment agreements because Johnson is out there.
Yeah, well, there's going to be a lot of names of documents purporting to protect people that will all be subject to more litigation.
Yeah.
So law students, study labor and employment law, because there's a lot of work out there, and it's just starting to happen. But Michael, so let's say we get to this, whether we do or don't get to the threshold of are they employees or are they not employees. A few years ago, Jennifer Abruzzo clearly said, oh, these scholarship athletes are employees. And that sort of shook up a lot of people. But do we need to get to a clear understanding of employee status for collegiate athletes to become bargaining agents, to have bargaining agreements? Are there other ways to get to it? And is there any sense of what this bargaining unit would be? As in, is it all college athletics? Is it by sport? Is it by school? Is it by conference? Is it all of the above?
Thank you for that question. It's one that I relish the opportunity to comment on. Before that, though, I first want to say that that's why I'm so proud of my partner, Allison. You can see how astute her legal arguments are. The question would be ultimately whether this is a legalistic resolution that is going to take place, because as you say, regardless of what you call them and how effectively we can present those arguments on behalf of the management side of the table, is that really going to be the ultimate answer? So with that background, let me shift to Jennifer's memorandum, which of course has now been vacated. So you've kind of gone through this scenario where in the first Trump administration, of course, the general counsel took the position overriding an earlier general counsel's position under Obama, hinting towards the fact that, hey, wait a minute, this is the duck theory, and they are employees. So then during the Trump board, that got set aside. Then, of course, under Biden, when Jennifer, who I have had the privilege of knowing, and she's a very smart, very dedicated, very thoughtful and reflective advocate on behalf of unions, and clearly her position started the trend line that we were all kind of dealing with until, of course, the brakes got put on that. Even though the Dartmouth case was successful, that her position was her position was overtaken by events, because when the administration relieved the board members, the Democratic board members, so the board doesn't even have a quorum, let alone a general counsel. So they have an acting general counsel, Bill Cowan, who was the regional director in LA and Region 21. And he, of course, as part of his review, has vacated that decision. So with that in mind, we don't actually have the imprimatur of the NLRB anymore at this moment. So if we move into, do we really need it? I think the short answer is no. We don't really need it, because the reality is that those elections were contested, adversarial, went through the board certification process. There, of course, is the concept of voluntary recognition. And then under the Biden board, that was something that they were really trying to facilitate and make it easier for unions to become the representative. So even if we set aside the issue of, are you an employee, are you an independent contractor, what you are, I think you could still clearly have a framework for collective resolution. And again, taking off my management hat, the story of the American labor movement is the story of America. If you watch the evolution of how did we get to the National Labor Relations Act, it was to frame and resolve disputes. Now, I've had, if at least I've lost track, 500 collective bargaining negotiations representing companies, 500 scenarios where employees have filed for unions have companies that successfully take the position that the unions don't add value. This is kind of a new space, and you can debate what the value would be. But one scenario would be that there's a way for the entity, the organization, whether it's at the NCAA level, whether it's at the conference level, whether it's just Division I schools, that could operate this. And in thinking about this and dealing with so many different unions in all kinds of workspaces, from auto manufacturing to hospitals to now technology. And I think that also gives us a little signal, the highly publicized cases involving Amazon or Starbucks or Apple. Those are things that we didn't see in this space at all. So I think we're now, again, into a new area. And are there unions, and what would that model look like? That's what's needed to be sorted through. Now, in my exhaustive research, which going to Google included in preparing for my remarks, just make sure I didn't miss anything recent, my own theory had been, and I have no portfolio for this, but in the industries I've dealt with, quite frankly, the most attractive model to fit the multitude of different entities and the disparity between the lowest level athlete in terms of revenue, not in terms of skill or athletic capability or anything like that, is where it's in the entertainment industry. Because if you think about it, the SAG-AFTRA model provides for a nationwide agreement with minimum standards. And those standards apply to everybody. The person that works 5 days a year and waits tables for the rest of the year, and the superstar A-list clients. So all of the basics are included at a national level. Hypothetically, that could be the NCAA. What's the uniqueness of the SAG-AFTRA model? They have 25 subregions, and those subregions deal with both different substantive areas. The big issue they've had now is in reality shows. Are people who appear on reality shows, are they employees of that show? What are they? Well, SAG, of course, is saying, hey, we should have an agreement for them too. So I think that the breakdown that and the beauty, at least on the surface, of the SAG-AFTRA model is that you could have a big agreement with national minimum standards. You know, how long is practice? Do we get time off? Do we get free food? Whatever it may be. And then the submodels could be either the conference or it could be an individual school. And the framework that you see there, and you know, ironically, when again during my my quick research here, there's about 190,000 college athletes in Division One. There's about 180,000 SAG members. But how many SAG members could you actually name? Maybe 10 or 15 of your favorite kind of movie stars. And of course, they're the people that don't need SAG. And you have that same kind of scenario here. And I think the beauty also of this potential hypothetical model is that there's no restriction for your superstar quarterback and the person that is playing volleyball or in a sport that doesn't generate that kind of revenue. They all have a common interest in certain work conditions, and the issue of compensation would be open. And that's pretty unique, because if you look at an auto workers contract or a Teamsters contract, they're looking for having uniformity, no matter they don't want superstars in the plant and people that don't perform in the plant. They want people that show up and do their job and are all paid, and they all have certain criteria for enhancing it. So, you know, that's my big picture kind of potential review. I think that is one thing that is going to probably have to get a more serious look as time goes on.
So this is a question for both of you because it touches on both of the things you've talked about, and it's a question that's been rolling around in my head for a few years now, which is, if we get to a point that students are getting paid directly by the universities, calling it a license, calling it a whatever, what happens to the value of the scholarship? Do we say magically that, oh, that scholarship doesn't count as income to you, but all of these benefits do? I mean, what are we doing there? And this sort of begs the question, do we need to have federal law to get around some of these taxation issues?
Yes.
Yeah.
So I've thought a lot about this from the employment front, like from the, could scholarships. So one of the big questions on the employment side, at least for schools that offer scholarships, is could scholarships be converted to wages, right? Like if could they, because there's obviously the question of like, can schools afford this? If this was the future, if the Third Circuit decides that this is where they're going, if another circuit, another court does it, how are they going to afford this? Is it going to mean the loss of all the Olympic sports? Is it going to mean the cutting of the non-revenue generating sports? And there has to be a way that doesn't happen. There has to be a way that doesn't happen. And I think for schools that offer scholarships, the question is, can we get to a point where sort of it could be a revenue neutral model for schools? But as it currently stands, so in a little wage and hour nerdiness, like the FLSA allows an employer, as it currently is written, to count as wages the reasonable cost of like room, board, and lodging. But so we can envision a portion of the scholarships could be considered wages for that reason, the portion of the scholarships that's covering room and board. But we need further legislative changes to allow the scholarships to cover tuition. There's nothing that would allow you to use a scholarship to cover tuition. So the way the FLSA is currently written, those couldn't be, the way the scholarship is, your wages couldn't be used to cover tuition. And there's also, you have to be paid minimum wage for all hours worked, and you actually have to have minimum wage in your pocket. So there have to be legislative changes in order to get to the point that you're reallocating scholarships as wages, or scholarships would have to go away completely and you've got to pay your own tuition, but then of course, how do you do that if you haven't earned you haven't earned it yet till the end of the year, because presumably you'd earn it over the course of the year. And then also, I mean, obviously there's also the tax exempt status of scholarships, and what do you do? Because it's wages, you're going to be taxed on it. There's the immigration issue that comes out of all of this. So there's a lot. And actually the Third Circuit, the concurrence in Johnson previews a lot of this in terms of what would need to change in order for an employment model to take place. And I think it all comes part and parcel with the scholarship question, but I'll let Mike take it too.
No, I think that's exactly right. I mean, to unpack a few of the points that you made at the outset, it's very likely that, and whether or not that would be accomplished, not certainly anytime soon, but, federal legislation, I think, is going to be important. I mean, another reason I think the four big, the professional athletes, the benefit that they get through this collective bargaining mechanism, of course, is exempt from antitrust protection. So that's something that, if you were looking to make a case for the university as to why they might want to consider it, or the league or the NCAA, which I know all of whom are right now, that would certainly not be their position. But, that's something that's involved. The other reason is it sometimes takes that type of resolution. A quick sidebar in another very unique area historically, after Vietnam, there was an effort to organize the military into unions. I happen to be serving at in the I was one of the poor officers ever, but I got plucked out of the system, and because they said, "Hey, Marino, you're a labor lawyer, right?" And of course, your response is always, "Well, I'm whatever you need me to be, sir." But so I actually worked on the draft of that legislation, which became law, which prohibits members of the military from joining unions. So whether we end up with something that says, "Hey, you ain't never going to be a member of a union if you're a college athlete," as a result of federal legislation, or the opposite, that framework, is something that is certainly also going to be in play. Because all of the issues that Allison makes reference to, that's part of what happens in a well-established collective bargaining relationship. Those are all subjects of bargaining. How would you gross up what you pay? How do you get this covered? Is that considered the minimum? That, in other words, one proposal could be that you have to be a scholarship athlete in order to be eligible to be a member of the union or participate in bargaining. So there's all kinds of different variations, but not until you cross over, in that area.
Well, there's a lot going on, so I just have a couple questions for you. We can call this our lightning round, if you will. Do we get a settlement in house?
I think so.
Okay, so we get a
Yes,
settlement
I'm
in house.
deferring to Allison.
The next question is, how many tranches of litigation follow that settlement?
Oh God, lots. So obviously Title IX.
That's where I'm glad you said that, because from the jump, it's and all some of the other cases that have come up are saying, what about Title IX? And even Kessler at the conference said, yeah, well, that's not covered here, but yeah, there'll be litigation about that too.
Yeah.
Does that would seem to be the wedge that keeps the distribution from those monies from happening? You go in and you say, I'm seeking an injunction on distributing any of this money because it violates Title IX on its face.
Yeah. So I think possibly. I think, again, it gets back to how schools are structuring the agreements that they offer. So if schools are doing the revenue sharing type of agreements that I was talking about, where it's like, look, we'll share a portion of whatever the revenue is that's generated from, and you get the same offer that say it's every athlete gets some percentage up to the cap, something like that. There are ways to structure this that every athlete gets the same offer, there's an argument that that complies with Title IX. The amount in the end might be different, but the offer and the benefit is the same. And the opportunity to raise that revenue is the same. So there are ways to structure these deals under Title IX that could comply. So there are going to be schools that are in compliance. It's not going to be a class action. It shouldn't be a class action or certifiable as a class action on Title IX grounds. So there are going to be schools that are in compliance. There are also schools, right? Like there should be schools that are offering the same deals to men and women athletes, and that are offering the same, if it's even just a pure, license, that are offering the same amounts cash wise to male and female athletes. But yes, there is absolutely going to be Title IX litigation coming out of this. And I think you can see that by just the number of people who have joined plaintiffs' law firms in the last 2 years. So,
Yeah, well, from really quick, from my perspective, I think that if anyone thinks that the male and female athletes will get the same amount of money, they're probably expecting those checks to be delivered by the Easter Bunny. But that's
agreed.
just my opinion.
Agree. At least at the institutions that get all the news, right? At least in football, and at least in the institutions that get all the news. There are lots of other D1 universities that are probably in compliance, but the ones that are covered by the news and the giant deals that we all read about all the time, you are absolutely right. I agree with you. Unfortunately,
well, I think it's another plug for the if you will, the collective bargaining process, because whether it's Title IX or any of the other distinctions among athletes or sports, at least in theory, you would try to develop objective criteria that would demonstrate this is the basis for the decision, and that might include revenue and other kinds of things that are not based on gender. So, once again, I think that as they're looking at the landscape of frameworks of potential resolution and minimizing litigation instead of fighting over litigation, again, there is at least the potential to address those in a positive way with objective standards and criteria.
This has been really great, and I could keep you guys here all afternoon because this is a really interesting area of law. For the law students out there, you want to get a job, you're looking for work, take the labor and employment courses because there's a lot of action there, especially in the college space. We're going to wait and see what happens once House gets settled. And then we're going to see what litigation follows on the heels of that. But certainly we're going to see some. From my perspective, I'm just going to keep saying quack, quack, quack. So thank you two very much. And for those of you out there watching that aren't members of the Sports Lawyers Association, what's up with that? Go to SLA.org, to sportslaw.org, and become a member of the Sports Lawyers Association so you can take part in all kinds of the great stuff we have behind our paywall and all the great newsletters and information that you get in addition to your subscription to the Sports Business Journal. So, Allison, Michael, thank you so much for taking the time today. Really appreciate it. And thank you for your firm support of our organization.
Thanks for having us.
May I need, if I may, I want to squeeze in one shout out, because in that Google search, even though I thought I had come to all these great insights on my own, it turns out that there was a fantastic article that I think everyone should be reading, that in what was called the Journal of Legal Aspects of Sport. Now, I had never heard of that, but in 2024, 4 professors that you would see in the article, it's very easy to find. I found it again through my basic search there. Talked about this very issue. They obviously come with a union perspective, but look, not only are unions the way to go, but one model that is already out there is what we made reference to take a serious look at, which is the SAG-AFTRA model. So I just want to make sure that they should certainly, I think, be getting a second look as things go forward.
Well, thank you for that.
Joseph Savin.
Appreciate that. Always. Yeah, no, I think you for the law students out there, guess what? You get out of school, you're still doing homework. That's our job.
Exactly.
So thank you again for taking the time today, and we'll see you soon.
Thank you.
Thank you.
Thank you, guys.